Writing Lawful Natural Product Ad Copy. Presenter Ralph Fucetola, JD. VitaminConsultancy.com. In cooperation with NaturalHealthOptions.net. This webinar is presented by Ralph Fucetola, JD, 36 years practicing attorney, 1971 through 2006. Expertise in DSHEA product development. This webinar covers DSHEA and nutrient claims, 3 levels of allowed claims, FDA claims substantiation guidance, allowed and disallowed terms, common mistakes, the revised FTC testimonial rule, varieties of substantiation, traditional uses, and substantiation and other resources. The webinar ebook includes all the text on these slides and more. Let's start with the 3 levels of allowed claims. They are general wellness claims, like take vitamin C and feel good. Or DSHEA, that's Dietary Supplement Health and Education Act of 1994, structure and function claims. They characterize the relationship between a nutrient and the normal structure and function of the body. And finally, health claims, which require prior FDA approval. These characterize the relationship between a nutrient and a health condition. For example, the famous folic acid and birth defects claim. Disallowed, of course, are all medical claims. Any claim to prescribe for, diagnose, prevent, treat, or cure a disease condition. See my white paper on the distinction between the treatment of disease and therapies that may benefit, entitled Alternative Practices and the AMA Code of Ethics. FDA substantiation guidance. What is the substantiation standard for your claims? Quote, the FTC standard of competent and reliable scientific evidence has been defined in FTC case law as, quote, tests, analyses, research, studies, or other evidence based on the expertise of professionals in the relevant area that has been conducted and evaluated in an objective manner by persons qualified to do so, using procedures generally accepted in the profession to yield accurate and reliable results. End quote. In this section of the webinar, we're going to start to look at some of the allowed and disallowed terms. Now, a little background here. In 1994, the Dietary Supplement Health and Education Act was adopted by Congress. It allowed us for the first time to make claims about dietary supplements and health foods. You may remember back in the 1990s, the FDA would raid health food stores and pull down the signs from the stores that said on them, health food store, because you couldn't say health and food in the same sentence. Congress stopped that nonsense and allows us to make what are called normal structure and function claims. And those claims have a certain set of words that are applied to them that are allowed and that have been allowed by case law and by other decisions. On the slide number 4 that you see before you, there's a list of some of those words, such as stimulate, support, regulate, and maintain. These are, of course, the main terms. Dietary supplements support normal structure and function. They don't change normal structure and function. That's something that drugs do. And dietary supplements are not drugs. And what is the distinction? It is the intent of the seller that determines whether a specific substance is a drug or a dietary ingredient. Well, any government that thinks it has the authority to regulate what we speak, despite the words of the First Amendment that says Congress shall make no law, Congress has made a law. And that law allows and disallows certain speech according to the FDA. Some of the words that it disallows are listed here on slide number 5, and they're pretty clear. I mean, words like antibacterial or antimicrobial or antiseptic, these are terms that are used in medicine. Mitigate, prevent, cure, of course, is the word that's most significant here. And these are a series of words, some of them, 4 of them exactly. Congress have to be on the label of each and every dietary supplement. but we'll get to those details a little later. Right now, just take a look at slide number 5 and get a general idea that terms that are about diagnosis and treatment of disease are terms that are not allowed under current law. Slide 6 continues some of these allowed and disallowed terms, and these are terms that are allowed in context. And you've got to be careful about these terms and probably ought to have advice from someone like myself when using them. And they include such words as promote or augment or modify or improve. These have to be very careful. The term supports the immune system is, of course, of primary importance and must be carefully used. One of the steps I've taken, as shown here on slide number 7, is to work out some alternative terms between the NG terms and the OK terms. It's important to be able to have these alternatives so that you can talk about the benefits of your products. This is what we mean by substantiated copywriting. And a good example, the word symptom is clearly a medical term, and it can't be used to describe what the effect of a dietary supplement is. But you can use the word indication. The word allergies is a medical term, but hyperreactivity is something that can be discussed in context of foods, including dietary supplements, and so on and so forth. On slide number 7, pain. Pain is an important one. Can never say pain when you're talking about a dietary supplement, but discomfort or soreness, or better yet, talk about it in a positive manner, and that positive manner is comfort, not pain. There are, as we list here on slide number 8, some common mistakes that I need to go over with you in detail if you're going to apply them properly to your copywriting. First of all, you have to avoid the use of any medical claims or medical terms. These are never allowed. Using unapproved health claims is also not allowed, or using unsubstantiated structure and function claims. Now understand the distinction between a health claim for which you have to get prior FDA approval. And by the way, there are 24 of those claims, and they're important claims to be able to use for specific nutrients. And compare that to structure and function claims do not require prior FDA approval, although a structure and function claims notice is required to be sent to the FDA within 30 days after marketing a particular claim. Now, the other problems include using inappropriate traditional use claims, and we'll get to those traditional use claims a little later. Providing non-DSHEA use instructions. For example, transdermal or sublingual delivery systems are not allowed. If you say about your pill, melt in mouth, you've got a drug. That's sublingual. If you say melt in mouth and swallow, you've got a dietary supplement. Got it? So you can't refer to third-party medical literature either. However, you can refer to third-party nutritional literature. Very important distinction. There are also issues about the incorrect use of testimonials, the failure to include the statutory disclaimer that we've mentioned, and making any claims on the actual label. I advise never to put an actual claim on the label. Yes, it's true. The name itself is a claim. Can't avoid that one. But keep your label clean. Remember, the FDA can seize the product if the label is unlawful, but if it's the other literature that's unlawful, the FDA will almost always merely give you a warning and let you change the literature. Well, be careful also of incorrect use of visual images. Work with a good videographer. For example, the FDA gives, as an example, in one of its publications, the use of a heart monitor type graphic line that goes up and down. Only it goes up and down in a way that suggests that there's some problem with the heart. And if it does that, then the image itself becomes an unlawful claim. You've got to be very careful about images. Videography, image control, absolutely essential. Get yourself a good videographer. The changes to the Federal Trade Commission, the FTC testimonial rule that occurred a few years ago are really key. The results not typical disclaimer is a safe haven no longer. Will consumer reviews replace testimonials? Very important question. The rule made in 2010 requires that all testimonials be examples of typical results or that the typical results must be declared. This means that you have to be very careful with the way you use testimonials. I have additional webinar work on testimonials that would be very useful for you to understand. But for the purpose of this webinar, just remember, you can no longer say results not typical and say whatever you want as a testimonial. Today, the testimonials have to be at least within the range of typical results, or you have to declare what the typical results are. How do you know what the typical results are? For that, you need proper substantiation. The key to proper testimonial use is only using testimonials that are substantiated. A testimonial is a claim. It is not substantiation of a claim. Very important distinction to remember. There are several varieties of substantiation for your claims. These include authoritative statements of the government. For example, FDA health claims approvals or United States Patent Office determinations. Few people realize it, but the FDA and the FTC are obligated by law to honor the Federal Patent Office determinations. Any approved claims in a Patent Office determination are considered to be legally substantiated. The next level are peer-reviewed and published articles. For example, PubMed, dietary supplement database articles. A third one are clinical tests, studies, and trials. And that's important, especially if the vitamin company involved has the resources to engage in that sort of study or trial. That is the most powerful substantiation of all, because it's about the actual product and not about the ingredients that make up the product. And by the way, if you make a claim of synergistic effect of several ingredients working together, you need substantiation of what happens when those ingredients work together. And finally, there are traditional uses claims, which have some special rules that apply to them. You're allowed to use them, but you have to make sure that it's clear to the consumer that you are describing a traditional use claim and not describing a current scientifically validated claim. Those traditional use claims are claims based on historical or traditional use, and they should be substantiated by confirming scientific evidence, or they should be presented in a way that consumers understand that the sole basis for the claim is a history of use of the product for a particular purpose. That's a statement from the FTC, and let's parse that. The claims based on historical traditional use have to be substantiated by confirming scientific evidence. If you have that, that's good. Or, FTC says, they should be presented in such a way that consumers understand that the sole basis of the claim is a history of the use of the product for a particular purpose. So you'd, of course, say in that context that there is no current scientific substantiation for this use, but it has been used for thousands of years, hundreds of years, in whatever manner. It is an important area, traditional use claims. By the way, you cannot make a medical claim using traditional use. These have to be claims that still fit within the Dietary Supplement Health and Education Act, the DSHEA, limitations on structure and function claims. On our next slide, number 12, are some substantiation resources for you. Some places where you can find useful information to help you guide yourself in this great issue of substantiation. Some of my white papers may help with that. Certainly, the FDA has very clear guidelines. Some of us would think a lot of bureaucratic gobbledygook in that stuff, but that's what I'm here to do: help you understand where the guidelines lead us. Let's consider that a little bit. For example, back when the structure and function rule was published back in the year 2000, it's a page-and-a-half rule, and it's, as I said, bureaucratic gobbledygook. But preceding that page-and-a-half are 90 pages of commentary. Now, under the Administrative Procedure Acts, when the FDA wants to make a rule, it has to first propose the rule and ask for public comments. And that's what happened with this structure and function rule. And the comments took the case of a series of this phrase or this word should be allowed or should not be allowed when talking about dietary supplements. And FDA responded to several hundred of those comments. I think there are 300 paragraphs in that 90 pages of commentary. And I went into that and downloaded it, and I stripped out all of the discussion, and I ended up with 4 pages of terminology that can be used with dietary supplements and of what the FDA thought, whether they were allowed or disallowed. And from that master list, I've developed the lists of allowed and disallowed terms that we've been discussing in this webinar. And in the webinar ebook, of course, there is a more complete listing of those words to help you with some greater detail. So here it is, substantiation resources. You have to be able to substantiate the copywriting that you're doing. That is the key to lawful copywriting. Slide number 13 includes some further resources that will be useful for you. You'll find these listed, of course, on the ebook. I think you might find especially important my standard operating procedures website, www.sopcertification.com. The FDA says that whoever owns the dietary supplement label is the responsible party, and as the responsible party must be in a state of control. And how do you do that? You do it by having written standard operating procedures that guide the staff and also the contract manufacturers and others that are part and parcel of the entire process of going from the idea of a dietary supplement through to the implementation, the marketing, and the delivery of the dietary supplement. Standard operating procedures. You're dealing with foods, and you have to make sure the public is protected. Thank you for listening to this Lawful Copywriting webinar from Ralph Fucetola, JD. The Lawful Copywriting ebook includes all the information on these slides and an expanded listing of allowed and disallowed terms. Always remember you have to use the Dietary Supplement Health and Education Act statutory disclaimer on your labels and on your literature. Quote, "These statements have not been evaluated by the Food and Drug Administration. This product is not intended to diagnose, treat, cure, or prevent any disease." End quote. Now, of course, FDA has no legal authority to evaluate statements made about dietary supplements, at least not if they're structure and function claims. And of course, this product is not intended to diagnose, treat, cure, or prevent any disease is an expression of opinion that Congress is compelling you to make. Is that lawful? No. Is it the current status of dietary supplement copywriting? Yes. You need to keep your mind on the prize, and that is to communicate lawfully about the dietary supplements that you are writing about. Thank you so much, folks. You can find a lot more information at www.vitaminconsultancy.com.